Hello everyone. Say you're a physician and you have a serious issue with your employer. You try to reason with them but to no avail. You want to file a suit, but you are pointed to the contract where there is a mediation or arbitration clause. So is having a mediation or arbitration clause good or bad? My name is Premkiranreddy, founding attorney of Reddy's law firm. I will lean on my training and experience in both the medical and legal fields to answer these questions. Today, we will primarily discuss about mediations. Some mediations are court-ordered and some written into the contract. If you look at other contracts, such as your cell phone contract, you might be surprised as to how many of them actually have arbitration or mediation clauses instead of going to court. Now, when you make your contract, try to find out which dispute resolution service or which dispute resolution guidelines will be used. You should find out if the mediator you choose has knowledge of the subject matter and experience resolving disputes in your field. So when you have a dispute with your employer, the first thing to do is go to them and bring up the issue with them, try to reason with them, and come up with a workable solution. Sometimes there are other underlying issues in play, and when you resolve them, the current problem is solved. Other reasons for impasse in disputes are personality traits. First, check yourself to see if you have any traits that are the cause of the impasse, and remedy them. Now that you have cleared that, look to the other side. Is there anything that makes you realize that after genuine good faith and repeated compromise offers, they just won't budge? If so, you can use that mediation clause in your contract. Even if you have a contract that does not specify a mediation clause, as long as the other side and you agree, you can still go to mediation. Mediation is a useful tool because sometimes, even if the other side wants to apologize or settle, they just won't do it with you. But they will yield to another adult in the room, such as a mediator. The advantage with mediation over arbitration or lawsuits is that the mediator can help the parties reach an agreement that is amenable to both sides, and all parties can continue to have a good relationship with each other. Mediations are confidential, but there may be exceptions depending on the jurisdiction that you are in. Mediations are less expensive and can be settled faster than lawsuits. You can even elect to do mediation remotely. This way, you will not have to take time off from work, and you do not have to be away from your patients for too long. You could be in your office and schedule a time in between patients. Sometimes online mediations can be better and can even level the playing field, especially if one party is more intimidating in person. Once a mediation agreement is made, make sure all parties sign it and the principles of contract law apply to the agreement. Mediation also works if you find yourself having to resolve disputes with payers not paying your claims, asking for the money back, or changing the fee schedule on you. Remember that before you go to a mediation, your hospital or clinic could have a policy in place about other in-house dispute resolution options. Mediate early rather than late. So to recap, mediation can be a good tool to have to resolve conflicts and impasses, as it is often quicker, confidential within the bounds of the law, more cost-effective, and you can continue to have a good relationship with the other party even after mediation ends. Please also be on the lookout for my series of videos on various other topics including contracts, ethics, malpractice, health law, and dispute resolution. Thank you for watching. Hope to see you soon in the next video. Bye-bye.